received, you said you can't tell this court about the training, whether in-house or any kind of a training you have received. You remember yesterday?
Izolo-ke nkathi ngikubuza-ke mayela nokuthi ukwazi yini okufanele ukwenze nkathi uya laphayana kwisini wasuthi-ke akwazi-ke uyitshela lenkantolo mayela nama-training owawathola noma ama-course owawahamba-ke phakathi emaphoyiseni.
Ngathi ngiyakwazi.
No, uthe awukho kwisimo sokuthi ungayitshela inkantolo ukuthi awapha ama-course owahambile yiphi training oyitholile.
Ngoba awekho wonke la ekhanda lami.
Yes, because I couldn't think about all of them from my head, the top of my head.
Yes. And then you requested that if you can bring them tomorrow or you can make a list, you'll correct me what you said yesterday. You said you can make a list or you can tell this court today about those training that we have received.
Uzongilungisaka uma kuwukuthi ngenza iphutha okushilo-ke izolo ukuthi uzokwenza noma uzoza nawe namuhla.
Yebo kunjalo.
That is indeed correct.
Yes. Can you tell the court?
Ungayitshela-ke?
Bengithi ngizokwenza into ekahle ngiwacele lapha emsebenzini ukuthi bangiprintele khona. Kwawukuthi ngishawa isikhathi ukuthi HR bavala ngo4 ngaphuma late lapha.
Sorry, I was under the impression or I thought that I would do a proper thing by going to my workplace to request them at the HR to make a printout for me. Unfortunately, they closed at 4, so leaving here, the time was against me when I left the court.
So as a result of that, you cannot be able to tell this court whether we have received any training or not.
Ngenxa-ke yalokho awukho kwisimo-ke sokuthi ungayitshela le nkantolo ukuthi i-training wayithola noma cha.
Kodwa ngithe mase ngimabheka kamanye endlini nje sengicabanga mina ama-course engiwenzile ngingabala i-domestic violence, vulnerable children, first responder to the sexual offense, then nama-shooting practice.
Okay, maybe let's start one by one if you are now mentioning them. Number one, you're saying it's a training on domestic violence.
Yebo noma ngeke ngisabala iminyaka ukuthi kulonyaka so ngangikanje. Yes.
Yes, although I can't be specific and attach a year and said by this year I did this course.
Okay.
Kwaba domestic violence.
Yes, that's number one.
And vulnerable children.
Okay.
Then kube first responder to the sexual offense.
Okay. That's all.
Ngisawakhumbula ngathi lawo then ke kube ngama-shooting ke practice ke.
Those are the ones that I'm able to remember. Then you have the shooting practices.
Okay. At the college, other than trained to drill, were you also trained? Did you receive any training regarding the crime scene, duties of the crime scene?
College-ke ngaphandle kokudrill nje ama-training wona-ke ukuthi uma uya kwi-crime scene ukuthi kufanele wenze kanjani wona nawe athola.
College phela sikwenza konke college.
At the college we do everything.
Okay. So in other words, we have received a necessary training regarding the duties that you were supposed to conduct at the crime scene.
Okusho ukuthi-ke ama-training ukuthi kufanele wenzeni uma kwi-crime scene lokho wona kona waqeqeshelwa.
Yebo college.
Yes, at the college.
And you were reckless in leaving the crime scene with Mr. Khumalo.
That's a good place, my lord. I think that is an issue that council can raise in argument.
Can I rephrase, my lord? Let's move on furthermore. After that, just one more question. Now, after you had left the crime scene with Mr. Themba Khumalo, do you know if there were any exhibits that were placed or removed inside the house?
Manje-ke emuva kokuthi senimshiyile-ke ubaba uThemba Khumalo laphayana ngabe niyazi yini ukuthi khona ama-exhibits asuswa noma abekwa phakathi endlini?
Ngayilutho ngophela ngoba sasingekho.
No, because we were not there.
Thank you, my lord. I've got no further questions.
Okay. Yes, Mr. Baloyi, any read?
No re-examination. Thank you.
Okay, thank you, sir.
Siyabonga-ke Nyembo, sir.
Siyabonga na.
As it please the court, my lord. My lord, I think there are new developments.
Hello?
I'm saying there are new developments
Oh, is that so?
in respect of Mr. Mnube.
Mr. Mnube?
Yes, that's
Is that your
accused number
client?
3. Yes.
Yeah.
Yes, my lord. This relates to count number. Where is it? It relates to count number 4. Yes. My lord, over and above the plea of guilty, I mean the plea of not guilty, not guilty.
What's the charge? What's count 4?
That it relates to unlawful
Ammunition.
possession of firearm.
Okay.
Yes, my lord. That's now over and above of the plea of not guilty. We are amending our plea to add a plea of autrefois convey. That is now in terms of section 106, my lord. I mean 106 subsection 2 of the Criminal Procedure Act.
Yeah.
Thank you, my lord.
No, but you just made a submission. You haven't supported the submission. Atrafoy convey.
Yes, my
It
lord.
means he was charged and he was acquitted.
No, he was convicted.
He was
charged
convicted.
and convicted of the very same offense relating
Relating to the same
relating to the very same firearm. Or
Same
weapon.
firearm.
Yes. That it is alleged.
And he was
in count
charged in which
number
court?
4. He was charged in Joburg.
What? Regional court, district
He
court,
was in the High Court, my lord.
High court?
Yes.
When was that?
That was in 2016, 2015. 2015, my lord.
20, no, but you must give me the full date, sir.
May I take instruction
Yes,
that
yes.
regard, my lord? I thought
And
that-
do you have a copy of the charge sheet?
No, we don't have it, my lord. The
No.
indictment? No, we don't
Yeah,
have
but
it.
you're telling me he was acquitted on a similar charge.
No, I'm not saying he was acquitted. He was
Atrafoy
convicted.
convict.
Convey, yes.
Hello?
Autrefois convey. Autrefois acquit, it's Autrefois. That's why
Was he acquitted?
Yes.
That's
But
it.
in
Where's the
this
charge?
instance-
I need a copy of the charge sheet.
No, in this instance, my lord,
Yeah,
he is saying
yeah.
he was convicted, which is autrefois convey. He served.
No problem.
Yes. So I thought, my lord, that for me for us to just tell the court that we are amending our plea to read autrefois convey, and over and above the plea of not guilty in terms of section 106 subsection 2 will suffice. It never dawned in my mind, my lord, that we also need to bring charge
Yeah,
sheet
okay,
and
fine,
proof.
fine, I hear you.
Yes.
So he was convicted of being in possession of which firearm?
The firearm that is alleged in count number 4.
Is that the Zech?
That is-
The Czech CPS?
We don't know if that is exactly the same
No,
firearm.
you see, that's the problem. I could have an R5 rifle, an R4 rifle. I could have had a revolver. I could have had a handgun. So you've got to give me the particulars, because if you give me those particulars, then Mr. Baloyi will have to respond. Are you with me?
Let me quickly take
Yes.
a 1 minute instruction, man. sergeant.
Yes, yes.
He's telling me that the firearm that was in issue here, it's the firearm that Mr. Dlamini and Mr. Masondo came to testify about. And the case was completed on the 27th, it was finalized on the 27th of July, 2017.
27th of July?
2017.
2017.
Yes, it relates to the evidence that was supplied to this court by Mr. Dlamini and Mr. Masondo.
So he was charged with possession of that particular firearm?
Yes, my lord.
Only?
My lord?
Only? He wasn't charged with possession of ammunition. He wasn't charged with possession of a firearm whose serial number has been erased. You know about that charge. You can be charged in terms of the Act 60 of 2000, if I still recall, right?
Yes, madam.
You can be charged with being in possession of a firearm whose serial particulars have been erased. You can also be charged with being in possession of a firearm
Yes, madam.
of a particular serial number. And you can be charged also with an ancillary charge of being in possession of that firearm,
Yes.
which was also, like the magazine we told about when they were making the firearm safe, contained ammunition without having a license to possess, ammunition from which a lawfully acquired firearm could have been possessed. Are you with me? So there are 101 charges. So
No.
which charge are you telling me about?
My lord, I'm specifically referring to what the state is alleging against him in count
here's the
number
state.
4.
You, those are instructions. I've been acquitted, I've been charged, and I served a sentence. What was the sentence?
No, he doesn't say he was acquitted, my lord.
Oh, what does he
says
say?
He was convicted.
Yes, what is a sentence? If you're convicted, you serve a sentence.
Man, I don't think that the issue of a sentence for now is relevant.
It
Because
arises.
Yes, it's got to
Ask
be
your
determined.
colleagues here.
No, it's not relevant, my lord.
What? You're charged with murder, like Ratam Khoshing. And then you say, oh, my sentence of life is not relevant. Is that what your submission is?
So the court basically wants all the
No,
particulars in
of
relation
course.
to this.
Yes. The court has a duty to investigate whether, in fact, what you are saying is correct. Then I'll go to the state and say, but this gentleman has served the sentence, or he's due to be sentenced, or there was a trial
Yes.
and he pleaded guilty.
I thought, my lord, that will come at the end of the trial.
No ways.
When the guilt or the not guilt of the accused is supposed to
No,
be
you told me
determined.
about acquittals and convictions.
My lord, in terms of the act,
What does the Act say?
the act says an accused person is entitled, over and above a plea of guilty,
Yes.
to plead any other plea, a plea of not guilty, to plead any other plea except for the plea of guilty. In other words, an accused person cannot plead a plea, he cannot tender a plea of guilty with any other plea. But in respect of a plea of not guilty, he can raise other pleas as well, including jurisdiction, autrefois acquis, autrefois convi, lack of prosecutorial authority, and all those.
And
That
I
is
must-
exactly what I'm doing.
And I mustn't know about whether that trial was finalized or not.
Maybe that's just a technical argument. my
It's
lord.
not technical.
You
It's
will
the
give
essence
that
of the
information
charge.
to the court, my lord.
It goes into the essence of the Mr. Baloyi, this is cause 1 criminal law.
Yes.
What do you say?
Well, my lord, this is new information that is being raised. We'll investigate that. But indeed, I think in terms of Section 106,
Yeah.
accused can raise various pleas
course, yeah.
at a plea stage. And the verdict thereon will then be relevant at the time when a verdict on the merits.
No. We're subjecting an accused person who is entitled to be presumed innocence.
Yes.
Is innocent. When he is being discharged on a particular offense, you are saying
Yes.
he must stand trial for that particular. Are you with me?
Yes, I'm with you, my lord.
Yeah.
But
So the court has got to know whether
yes,
he was charged and was there a trial and what was the result of the trial.
yes.
Because you can't be charged. Americans call it double jeopardy.
Indeed, my lord.
That's it.
Yes,
You can't be charged twice for the same offense.
Yes.
Me, if I'm satisfied what Mr. Mnisi is saying, that his client is being charged twice, I must intervene.
Yes.
But I can't intervene until the state has advised me that there's some merit in the submission Mr. Mnisi is
Yes, but
tendering.
But that will not be the end of the matter, my lord. If, say, for instance, an admission is made that, look, on that particular day, the accused was in possession of, that firearm and is already been convicted of that, then for the purpose of the current trial, that will then obviate the need to lead evidence regarding that aspect. But we submit that the effect of a conviction will not be the end of the,
Say, was he convicted? Was he charged with the very firearm which is described in the force? It's not
Yes.
the Cleveland. Is it the Cleveland or the
Yeah,
Alexander charge?
Yes, yes. There's something that we'll have to investigate, my
No,
lord.
you can't investigate. Then, of course, I must know, because I can't allow evidence to be led against an accused who has been acquitted or convicted of a particular charge to be again led. That's why when you get the end of the trial, the state is required to prove previous convictions.
Yes,
That's it.
yes.
Now, according to my colleague here, his client has a previous conviction. Hello, Mr. Mnisi.
My lord.
Am I understanding you correct?
Yes, my
He's
lord.
got a previous conviction.
I might not call it a previous conviction, my lord. I prefer to call it autrefois conduit.
Don't confuse issues. Does your client have a previous conviction of being charged with the possession of a firearm which is described in the Alexander or Cleveland case as a Czech CPZ firearm which did not have serial registration numbers?
He was found guilty, my lord, of those charges. Of that
Was he
charge.
charged with that firearm?
Yes, my lord.
Right. And he was found guilty.
He was convicted, my lord.
Found guilty, convicted.
Yes.
It's just semantics. He was found guilty.
Yes, my lord.
Right. Is he serving a sentence for that? Or was he imposed a fine?
No, he served a particular sentence.
Mr. Baloyi, are you with me? Did you hear what your colleague is saying?
Yes.
So that evidence, which was led by Mtimkulu Nomatebula, it's unconstitutional and unlawful because it relates to a crime which your Mr. Mrs. client was charged in respect of.
But my lord, the court will remember that during the Section 150 address, the state indicated that the state will aver that the firearm that was found in accused number 3's possession is being connected with the bullet point that was found on the scene.
Okay.
So the purpose of leading the evidence
All right.
will then be to indicate that the accused was in possession of this firearm, which is later connected to the bullet point that was found on the scene.
This is the...
That will be the purpose of
Yeah,
the
fine. I
evidence
hear
of
you.
the
This
two.
is a Czechoslovakian CPZ
Yes.
firearm.
Yes.
So it has got nothing to do with his conviction.
Yes.
Yes, Mr. Mnisi, what is yours? Are you saying that evidence is unlawful, unconstitutional, and irregular?
That is my sentiment, my lord.
Okay.
Thank you, my lord.
Is he serving a sentence for that? I don't have to, you know what? You're putting this court in an invidious position. I don't have to know about previous convictions of clients,
Yes,
of accused persons.
that is the reason why I say, in terms of the act, suffices for the defense to say we're pleading over and above the plea of not guilty. We also saying he also continues to plead autrefois conduit. That is, he has already been convicted of the offense that the state has preferred against him in relation to count number 4.
No, but they're relating it to the present count, which relates to a force lurus docket. Am I correct, Mr.?
Indeed, my lord.
It's not related to the Cleveland docket or the Alexander docket. Am I?
Indeed, my lord.
Okay, fine. Then I'll listen to the evidence.
As it is a court.
Okay, sir.
Thank you.
Right.
Mr. Mube uzokwazi ukuthi bekukhulunywa ngani ummeli wakho ebethsazisa inkantolo noma ichazela inkantolo ukuthi ngaphezulu kwalokho bese nikushilo ke ngaphambilini befisa nje ukuthi atshele nomazisa inkantolo ukuthi lobufakazi lobu bebuthulwa uMasondo la kanye naye uDlamini mayelana nesibhamu lesiyana abathi satholakala kuwena ukuthi ke isibhamu leso ke owachargewa ke ngaso wase futhi ke ulahlwa icala khona wase futhi kuba nesigwebo ke futhi osuyosihlalela noma soyosidonsa manje ke umehluleli asithi ke akwanele nje ukuthi anikezwe kufanele anikezwe imininingwane yonke iphelele mayelana necala lelo ngoba ke kuzofanele enze isinqumo ukuthi ke ingabe manje kuthule ubufakazi ngecala oseudonsile noma oseuhlelele vele ejele kodwa kumshushisa uma ngabe sephendula ke yena ke ukuthi lobo bufakazi bebungethulelwa idocket leli lase Cleveland noma elase Alexander ukuthi ke isibhamu lesi esatholakala kuwena isibhamu ke abasihlanganise ne point yenhlamvu noma I bullet point eyatholakala kwisini kuleli icala esibhekene nalo la enkantolo.
Okay. Yes, Mr. Baloyi.
As the court pleases, my lord, the state then calls the next witness. It's Sergeant Timothy Matebula.